What purpose does the lady from Surrey represent Stephen Jones?
To speak on the bill.
The lady has 4 minutes to make the bill.
Thank you, Mr. Speaker. And members of the House, partially this is a bill that I very much consider. I was in the Chief Justice's Commission on the Administration of Law and Justice, and one of the issues came up about whether we should expand the Supreme Court or not shortly after the election. And it became clear, as we listened to the experts in that room, that the Supreme Court doesn't have enough work to do. So, by cutting back on some of the Court of Appeals work, we're going to continue to send more cases directly to the Supreme Court. Currently, 80 of the most busiest types of cases, all the business cases and all the class actions will go there. That's an immediate 80 more complicated, complex cases that will go straight to the Supreme Court. You brought up the termination of parental rights, and that is one we started to go ahead and directly send up to the Supreme Court, but while we still have 15 members on the panel, we don't have to do that. So you may see us back here adding more to the Supreme Court load next year and the year after for that very reason. We are trying to equalize the loads between the two. I did have discussions with this with Chief Justice Martin. I did not have discussions with the Court of Appeals. The Court of Appeals, I'm sure, will tell me what they're telling all of you. We don't want our money, we don't want our numbers increased. Who wants their friends to lose their job? Now, on to the fact of the issues. I have the record from the Appellate Court Reports, Court of Appeals. It is called the North Carolina Judicial Branch 2015-16 Statistical and Operational Report. It indicates that there were only 2,100 filings for appeals and petitions in the Court of Appeals last year. That is down in the last 4 or 5 years by about 500 cases. The caseload is decreasing. Now, you can go in and add motions, and a motion can be anything, and frequently is anything, and encompasses any type of relief sought from the Court of Appeals, either in a case already filed, so it's duplicative of a lot of these, or on its way to the Court of Appeals. So there were some 3,000 of those motions, and a tremendous number of those were easily and quickly allowed. Petitions, I believe petitions are down too. So even on Judge John's statement of trying to quote all of these cases lumped in together, we are still down 600 or 700 cases, motions, and he was getting everything all together. It is an issue of trying to restructure the load and who should be carrying it. The Supreme Court has a significantly lesser load. They do write significantly more complex and larger opinions, but we are trying to equalize the workload, but that also equalizes the number of people on each court. I'd ask you to support the bill.